The Honorable, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon. We are here to have oral arguments in one matter this afternoon. This is State of North Carolina versus Ronald Jason Gibson, case number 20-219. I am Judge Lucy Inman and am joined on the panel here by Judge Allegra Collins and Judge Jefferson Griffin. Are counsel ready to proceed? Mr. Widenhouse, you'll need to unmute yourself, and if you could just confirm, are you wishing to reserve 5 minutes for rebuttal? Very well. Are you ready to proceed?
Yes, Your Honor.
Very well, we'll hear you now.
May it please the court, I am Gordon Widenhouse. I represent Ronald Jason Gibson in his appeal to this court from his convictions on 2 counts of felony hit and run in the Superior Court for Iredell County. And I do want to reserve 5 minutes for rebuttal. In this case, the state's evidence failed to prove an essential element of felony hit and run, that Mr. Gibson knew or reasonably should have known that someone was killed or seriously injured in a wreck. It is not enough to prove that a wreck occurred. It is not enough to prove that someone was killed or seriously injured in the wreck. The evidence must show beyond a reasonable doubt that Mr. Gibson knew someone was killed or seriously injured. Here, Mr. Gibson was driving a cargo van that was filled almost to the roof on the inside with furniture and other materials. He could not see what was behind him through his rear windows, either if he looked over his shoulder to try and look out the windows, or if he looked at his rearview mirror that was in the cab of the trailer, of the van. In addition, he was pulling a trailer behind the van. The trailer was 9 feet long, 5 feet wide. It was also packed or loaded as high as the rear window of the van that he was driving. The tailgate of the trailer itself was taller than the rear windows of the van. I think the tailgate was 7 feet tall, of course, would have gone from the bed of the trailer up with it closed. There were also no extension mirrors on either the driver's side or the passenger side of the cargo van. Quite simply, Mr. Gibson could not see what happened behind him. Because he could not see, the evidence was deficient to show he knew or reasonably should have known that anyone was killed or seriously injured. Substantial evidence did not show that knowledge, which is an essential element of this crime. Therefore, this court should reverse these convictions and remand this case for the imposition of judgments on 2 counts of misdemeanor hit and run. The statute in this case, 20-166A, is clear and has 6 elements. Someone must be driving. There must be a crash or some sort of wreck. Someone must be seriously injured or killed. The defendant must not have stopped at the scene, and his failure to stop must have been willful. So there are 2 independent aspects of knowledge when the crime is felony hit and run. 1, the defendant must know that an accident occurred. 2nd, the defendant must know that someone was seriously injured or killed in that wreck or crash. We think the evidence fell short on showing that the defendant knew or reasonably could have known that someone was killed or seriously injured.
I have a question. So the test is reasonably should have known. In this case, there doesn't appear to be any showing of actual knowledge. I would assume that you would agree that circumstantial evidence can be sufficient to show this type of knowledge, should have known?
Correct.
Okay.
Circumstantial evidence can prove the element.
Okay, so, and I understand that your argument is that that the trailer was long, the camper was long, it was packed to the brim. But in this case, did not the driver pass these two motorcyclists such that he actually knew where they were on the road before he moved over?
Yes, there's no question he knew the motorcycles were on the road and where they were before he moved over in front of them.
Okay, so if one is traveling at a high rate of speed on the highway and one moves over such that an accident is caused, is that sufficient in and of itself to show reasonable knowledge that someone's going to be seriously injured or killed who was on that motorcycle?
No, I don't think so, Your Honor. I think it's reasonable that would be circumstantial evidence that he reasonably would have known a wreck may have occurred. But knowing that a wreck occurred isn't sufficient to prove felony hit and run.
So it's your argument that knowing that a wreck occurred on a highway with individuals on a motorcycle, that's not sufficient in and of itself?
That's correct.
Okay.
Because not every motorcycle wreck would result in serious injury or death.
That's true, but I
Certainly it
guess
did
my
here.
question is, in this case, they're traveling on a highway, presumably at a highway speed. Isn't that enough?
I don't think so, Your Honor, because we don't know. He would not have known how fast the wreck occurred. Again, we're relying on circumstantial evidence that he even knew there was a wreck. So he wouldn't have known how the wreck occurred or how fast it happened or what speed the motorcycle was going at the time he laid down the bike, according to the truck driver who was behind it. Again, there has to be more than just circumstantial evidence of knowledge of the wreck. There's got to be circumstantial evidence of knowledge of death or serious bodily injury.
Mr. Whitehouse, if I can just ask you about another, I don't know if you consider this circumstantial evidence, but the fact that, according to witnesses, Mr. Gibson looked at the motorcycle drivers, made a rude gesture at them, engaged with them, could a jury reasonably infer from that evidence that he intended to cause the motorcycles to at least be at risk of being in a wreck?
I don't think the jury should infer intended for them to be at risk of a wreck. I don't think that any evidence of road rage, and I would concede that's sort of what this is. Road rage indicates an intent on the part of the driver for somebody to have a wreck. I mean, road rage usually, at least in the few cases where I've seen it in litigation, not that I've seen it in real life, I don't think that the drivers that were engaging in the rage had an intent to cause death or serious bodily injury. I'm not even sure they intended to cause a wreck. So I don't think it's a fair assumption for the jury to assume or infer that because he knew there were motorcycles and he pulled over in front of them and he either put on his brakes or tapped his brakes, the brake lights came on, that was an intent that he wanted to wreck the motorcycles.
Well, I guess what I'm thinking about is a moving motor vehicle at high speeds, as Judge Collins has pointed out. You're all moving at 70 miles an hour, and the witness's testimony that Mr. Gibson engaged the motorcyclists in pointing at them and verbally engaging them, and then moves his van with trailer into a position that forces the motorcycle driver to slam on his brakes. I think the evidence was that there was no evidence of skid marks for the van and the trailer, but there was for the motorcycle. Is that just First Amendment expression of his mood that day?
I don't know that I could.
That's why I'm asking, and I know it's a, you know, when the inference of intent can be considered as part of whether there's substantial evidence of knowledge.
Well, I don't, again, I don't see evidence of an intent to cause a wreck by pulling over in front of somebody and tapping them. I'm getting a lot of feedback, Your Honor. I don't know if it's my fault or somebody else. So, I mean, again, I think sometimes people get frustrated.
Judge Inman,
Yes.
try muting. If each person who talks is the only one with the mic on, it might work better.
Thank you, Judge Collins.
I know that sometimes I get frustrated on the interstate or on a road when somebody's, I think, following too closely behind me, and I want them to get off the tail of my car, and I might tap the brakes so they see the brake lights. I want them to slow down. I want them to back up. I don't want them to have a wreck. Now, there was a little more than that in this case, but the fact that he taps his brakes, I don't think is an indication he wants to cause a wreck. I think it's an indication he's just continuing his road rage or frustration. I don't think it's a fair inference that because he pulled back over in front of the motorcycle and tapped his brakes so that the brake light came on. Again, it might be a different situation if he pulled back over in the motorcycle and slammed on his brakes, and then you have skid marks by the van. Maybe that's more of an indication that he was doing something to try and cause a wreck. I don't think his pulling and taunting, admittedly inappropriately, but taunting the motorcycles is an indication he intended to cause a wreck. And even if it was a cause a wreck, and I know it's a motorcycle as opposed to a car, but it's a, you know, you assume that motorcyclists that are traveling the interstate, going 70 miles an hour in and out of traffic, that the driver of the cycle or the bike knows how to handle it and is prepared for somebody to go slower in front of him, and he might have to hit his brakes or something like that. Now, I confess I'm not a motorcycle rider. Never been on one, don't intend to ever be on one. But I would imagine that experienced drivers, you know, prepare for things like this. And so I just don't think it is a reasonable inference to draw that Mr. Gibson intended to cause a wreck, certainly intended to cause a serious wreck, because he pulled back over in front of the motorcycle. So I think it was more of his taunting. Again, inappropriate, but that seems like what he was doing when he was doing the rude gestures. And I think that he was yelling through his window and spitting out his window and laughing. I think it was taunting. I don't think it showed an indication he wanted to do anybody harm. So.
Just one more.
Oh, go ahead, Judge.
What about the 911 call that Mr. Gibson placed? And wouldn't it be a reasonable inference for the jury that he knew something had happened and that someone needed emergency assistance? Don't know why he didn't say anything, but could you speak to that?
Well, I don't know. Again, all we know, it was a short call to 911 and almost an immediate hang up. I think it lasted about 8 seconds. I don't know that the reasonable inference is he thought something had happened and someone needed emergency assistance. Keep in mind, he's being chased by a guy on a motorcycle that we later learned had a gun and was shooting at him. So, you know, he might have been calling 911. It could have been an accidental call. Again, we don't know. Again, I would assume he's not dialing 911. Maybe he has 911 on a speed dial or something. But even if he dialed 911, I don't think that's an indication that he thought he'd done something that caused a wreck. And even if he had, you know, if knowing there's a wreck isn't enough. He's got to know somebody was killed or seriously injured. And he's supposed to report any wreck. And so even if he knew, there might have been a wreck and wanted to call 911 for that reason, that still isn't sufficient to prove that he knew somebody was killed or seriously injured. Again, all of this, in my view, goes back to the car he was driving, the van that he was driving, how it was loaded, that it was pulling a trailer, and he didn't have any extended mirrors. And I've made every effort so far to try and get State's Exhibit 20 sent to the court. I don't think it's there yet, but I'm going to try with the clerk in Iredell County again. But I would urge the court to look at State's Exhibit 20. And what you see in that exhibit is the van pulling into the gas station. And you can see there are no extended mirrors. You can see how it's loaded inside. You can see the length of the trailer it's pulling and the tailgate being raised up. You can see it would be impossible for him to look in his rearview mirror and see what was behind the trailer.
I got a question. When we're talking about reasonably should have known that serious injury or death occurred, am I correct in that the same evidence is going to go to serious injury or death, such that either there was sufficient evidence in both counts or insufficient evidence in both counts?
I think I agree with you on that, that it would apply equally to both counts. I don't know how his knowledge of death or serious bodily injury would shift based on the person who died and the person who was seriously injured.
Okay. Thank you.
So again, I hope that State's Exhibit 20, that video, makes it to the court, because it gives you uncontroverted, undisputable evidence of what he could or couldn't see. And all of the state's witnesses said they didn't know what he could see from traveling behind him. That's why I think the Bridges case is so important, because Bridges is a situation where it wasn't road rage driving, but there was a serious wreck behind the person who was the defendant in that case. And he had pulled over, I think I actually know where the place was, on where I-40 and I-440 split off, going around Raleigh, where that occurred. And he was driving his mother's car, and he pulled over, swerved over in front of somebody, realized, I'm not supposed to be in that line, I'm supposed to be where I was, and he swerves back, and he doesn't know that the person he swerved in front of lost control of her car, ran off the road, crashed into a tree, and killed the passenger. He didn't have knowledge of death or serious bodily injury because the wreck happened behind him, and he wasn't driving a car that was loaded. He wasn't pulling a trailer. Apparently, according to the evidence in the case, any obstruction of his view through the rear view mirror or just turning and looking over his shoulder, it was unobstructed. And yet, the court in Bridges said that's not sufficient evidence, mainly because the wreck happened behind him. That's not sufficient evidence to show he should have known that somebody was killed or seriously injured. So I think Bridges is, although it's not controlling because it's unpublished, it certainly distinguishes it from other situations where the defendant hits somebody, he plows into the rear end of a car, or he hits somebody who's walking along the road. The defendant knows something's happened there.
Would you agree that we're in a different situation with a motorcycle versus a car? That's just a very different situation.
I think it's a different situation in the sense that, no, I would not say it's a different situation in terms of what he could or couldn't see. And if he
and what he reasonably could know might result from an accident on a highway, is it different than what might result in a car versus a motorcycle?
Well, I guess I would concede, Your Honor, that it's more likely that somebody's going to get hurt in a motorcycle wreck than a car wreck, nothing else appearing.
Okay.
But he still has to have some reason to believe that the motorcycle accident happened and was serious enough that somebody's killed or seriously injured. I don't think every motorcycle accident results in death or serious bodily injury. And that's a big distinguishing factor. Now, admittedly, they were going 65 or 70 miles an hour on the interstate, and people were weaving in and out of traffic. But the state's eyewitnesses are in conflict with each other as to what he could see and what the movement was. I mean, the person with the best view was the driver of the transfer truck, and he said Mr. Gibson didn't swerve back in front of the motorcycles. So, you know, it's hard to tell how much he could know about a motorcycle wreck versus a car wreck, certainly on the facts of this case.
So our review is in the light most favorable, correct, to the state?
Correct. You take the evidence in the light most favorable to the state. That's absolutely correct. But there still has to be substantial evidence to prove each element of the crime. And our position is there's just not substantial evidence of his knowledge of death or serious bodily injury.
Can you, if Judge Griffin or Judge Inman doesn't have any other questions on this, I'd just like to hear the argument on the jury instruction.
All right. Well,
I'd say I prefer the jury instruction at this point too.
Okay.
yes, sir. I'd be happy to address the challenge to the flight instruction in this case. And I would concede up front that there was no objection to the flight instruction at trial. So I have to hurdle the unenviable standard of review of plain error. But the genesis of this argument really rests in the notion that it's questionable what probative value ought to come from a person's leaving the scene. Okay, because just because you leave the scene of the crime doesn't necessarily mean it's consciousness of guilt. I mean, who in the world is going to stay at the scene of the crime if it's a crime they committed? So there needs to be more than just departing the scene to have serious probative value. The idea with the instruction is the language says, if you find that the defendant fled, you can infer consciousness of guilt for that. Our argument is that is particularly problematic, not just because flight instructions generally are problematic, but a flight instruction is particularly problematic if the jury might leap from a consciousness of guilt thought to, therefore, he must have known what happened. Or as in this court's case in Campos, you infer a bad intent based on consciousness of guilt. Consciousness of guilt just means you know something happened. You know you did something you shouldn't have done. Doesn't necessarily mean you had a bad intent, and the jury shouldn't be permitted to infer consciousness of guilt and from that bad intent, or in this case, knowledge of death or serious bodily injury. So that's really the nub of the argument in this case. And I'd sort of say it's kind of like when we instruct the jury on flight in a first-degree murder case. The instruction says you can infer consciousness of guilt, but you cannot infer or use this evidence of flight to show premeditation and deliberation. If I had been, well, I like to think if I'd been handling this case at the trial level, I not only would have objected to the flight instruction, but would have said, Judge, if you overrule my objection and you give a flight instruction, at least put a sentence or two in there that tells the jury, if they find he fled and therefore infer consciousness of guilt, you can't use that to show knowledge. You can't use that to show the knowledge element in this case. That would mirror the limitation to using flight, consciousness of guilt, to show premeditation in a first-degree murder case.
So is the argument, for example, that the consciousness of guilt may simply be consciousness that he flipped the bird at somebody and that was a bad thing to do?
Absolutely.
Okay.
I mean, I think he would know, well, I would think most reasonable people would know, if you're driving on the interstate and going 70 miles an hour and weaving in and out of traffic and flipping somebody the bird and spitting at them and yelling at them and taunting them, you've done something wrong. That's not what we're supposed to do. So at least it would be, they could infer that consciousness of guilt. The other problem I have with the flight instruction in this case is you can't convict of hit and run unless there's run. Okay, you have to flee for there to be hit and run.
But it's not fleeing. You leave the scene, and then the flight has an extra element of I guess the way that you are attempting to evade. What is it? Apprehension.
Except again, if you take the technical definition of run in a hit and run case, I have to know something bad happened. I have to have the knowledge that a wreck occurred. So, and it would be a wreck that I caused. So I think it's more than just leaving the scene when you have flight. Yes. I'm not hearing you.
That's because I too failed to click the unmute button. Thank you. I'm sorry. You know, this is the second issue that you're arguing about. The first issue is about knowledge. If this panel were to disagree with you and to hold that there were sufficient evidence that he had knowledge that an accident had occurred and that caused death or serious injury, the knowledge part that you're talking about has been dealt with. I mean, I'm just saying if that issue is decided, that will determine whether we may reach this second issue. And if we reach this second issue, the state submitted a memo of additional authorities with an unpublished case, the Barnes case, which talked about the manner of the departure and the subsequent eluding of police. And here, don't we have going to get his tire fixed, not telling the truth about what happened, asking if he can take some back roads to get where he was going? Doesn't that mirror the Barnes case? I know we're cutting into your rebuttal time, so if you wish to just say that's your opinion, that's fine.
Well, no, I see your point, but I still think that to allow inference from leaving the scene, which is an element of the crime, is still problematic when you don't tell the jury, okay, you can find consciousness of guilt, but you can't use that to show knowledge. And even though the evidence might at that point be sufficient to get to the jury, that doesn't mean the instruction is not prejudicial. And so I would argue that even if I'm unsuccessful on the first issue, the court would still need to address the merits of the second issue. I don't think Barnes is applicable because I read the briefs in Barnes and they're not making the pitch about consciousness of guilt in the same way that I hope I was trying to drive that point home in our brief. So I want to reserve the rest of my time for rebuttal and urge the court to reverse these convictions.
Very well. Mr. Dalton, are you ready?
Yes, Your Honor. Thank you. May it please the court, my name is Neil Dalton and with the Attorney General's office, and I represent the state in this manner. And I would like to start with the sufficiency of the evidence issue and point out that contrary to Bridges, in this case, the defendant knew exactly where the people on the motorcycles were. He was very much aware of that. And not only was he aware of where they were the focus of his attention. He was looking at them. He was making the rude gesture. He was yelling and spitting at them. He stuck his head all the way out the window. And then, according to the testimony, he immediately swerved over and tapped his brakes. And whether he actually saw the impact or not, the focus of his attention was on them. And he had side mirrors. And after the accident, the two people who were injured and killed, Miss Bell, who was killed, and Mr. Summerall, they went into the right-hand lane. So they were now in the right-hand lane. He was still in the middle lane. He could easily see them with his side mirrors, the side mirror on the van, not the mirror, the rearview mirror inside the van, but the side mirrors, he had side mirrors, and he could see them. And the motorcycle went flipping and flying and skidding over 2 lanes because there was an emergency lane, because the truck driver said he was able to get into the emergency lane to avoid hitting the 2 injured people. And the motorcycle then went up the embankment. There was no testimony about noise, but I'm sure there was a lot of noise. This is 60 miles an hour, and it broke into pieces. And I would argue, of course he knew there was an accident. Of course he saw it. And
I've got a question, just for argument's sake. Let's assume he could see nothing behind him. Is there still sufficient evidence that he knew or should have known there was an accident, and
Yes.
knew, should have known about the injury that might result with the death?
yes, absolutely. The bodies went flying into the next lane where he could certainly see them. And then the motorcycle went another lane over and then up the embankment where he could
Yeah,
certainly
my question is not about what may or may not have been seen. Let's just assume that he saw none of that behind him to the side of him. If we can't infer that he saw anything as a result of immediately swerving into the lane and tapping his brakes, is there sufficient evidence to survive the motion here?
Yes, first of all, tapping his brakes, I think is a misnomer. He slowed down substantially, which is why the motorcycle hit him or had to brake sharply to begin with. So he reasonably knew he caused this accident, or that he caused an accident. And certainly if people on motorcycles going 60 to 65 miles an hour get in an accident, they are going to be severely injured. And if there's any doubt based on what he should have seen and based on what he did afterwards is evidence of his guilt. He not only took off, he took off very fast. First, he slowed down, which is what we all do when you get in an accident. And then he sped up. So even slowing down quite a bit afterwards makes it look like he knew there was an accident. Then he sped up, he took off, he went at a very high rate of speed, weaving in and out. Mr. Elfin comes behind him. He's trying to get away from Mr. Elfin. Why? If he didn't know there was an accident, why would he try to get away from Mr. Elfin? All Mr. Elfin's doing is going the same speed he is. The gun wasn't shown yet. Mr. Elfin is no threat to him on a motorcycle, except to get his plate number and to call the police. And so he can tell the police where the defendant is, which is exactly what Mr. Elfin was going to do. And then then he started swerving over at Mr. Elfin. Again, why? Why did he do that? The gun wasn't out yet. It's uncontradicted evidence. He only pulled the gun out to keep Mr. Gibson from swerving over at him. So then he shot, and then apparently Mr. Gibson dialed 911. He hung up almost immediately. Why? Once again, just like starting to stop after the accident. He said, "Do I really want to do this?" No. He acted exactly like somebody who had caused an accident and was in deep, deep trouble. And he knew it. And that's exactly how he acted. Then he gets to the truck stop. He could have called police. He had plenty of time. He was there, I believe, a couple hours. And then...
So is it your contention that, contrary to Mr. Widenhouse, that his flight actually can be used to show evidence of his knowledge that an accident happened and potential knowledge that he knew the injury happened?
Certainly, it's part of it. It's part of what can be used. It most certainly can be used. And the other part, of course, is that he was directing this road rage and did something extremely dangerous. He pulled over in front of them and put on his brakes. And Mr. Widenhouse says tap. There's no real evidence that it was a tap. It slowed down enough that the motorcycle put on his brakes hard enough that they smoked. his brakes smoked, and he still hit that trailer. And this trailer was going faster than him to begin with because it had passed them. So he knew there was an accident. He acted like he knew there was an accident. He deflected the question, what happened to the tire? He said, oh, I had a blowout on I-40. And why would you deflect that? Why wouldn't you say some maniac has been chasing me and shooting at me? Because he wanted no part of the police. He was afraid that exactly what happened did happen, or he was afraid that exactly what happened would happen, which is that this person who changed his tire would realize. I mean, he called his wife and told him he was coming home, and the wife started telling him about this terrible accident, and immediately he recognized, oh my goodness, I just changed the guy's tire. That's exactly what Mr. Gibson was afraid of. That's exactly what happened. And then he asked how to get to Stony Point without going on the freeway. Why? Because he believed, I think it's certainly reasonable to believe, he believed the police were after him. And he did not want to be seen. He acted exactly like he was in deep, deep trouble and nothing but. And that is certainly one of the things he could look at. And certainly if a motorcycle gets in an accident going 60 miles an hour, there's going to be death or bodily.
Just for my own knowledge, is there a 60 or 65 or 70? Is that number in somebody's testimony? Is there an actual testimony as the speed?
Yes, Your Honor. Mr. Summerall, who was the driver of the motorcycle, estimated the time at which, when he touched that trailer, he was going about 60. And he said, and he might have even said 60 or 65. They thought they had gone up to 70 because they passed the truck, which was apparently governed at 65. So they passed the truck. So they were going more than 65. He estimated that he slowed down to 60, or he was able to slow down to 60 or 65. And after the accident,
I'm sorry to be dominating. I just have another question. Do you think that it is, I guess, almost per se, if we were determined that nothing else appearing, that a motorcycle accident on a highway at speeds of 60 or 65 is going to result in serious death, in serious injury or death?
Yes, Your Honor, I do. And nothing to flee or leave the scene. I mean, the operator of the vehicle doesn't have to go and check and see what the extent of the injuries are. I mean, certainly an accident at that speed would have caused that. But aside from that, I would still maintain there is enough evidence that he saw that accident occur that there was enough to turn that over to the jury and to let the jury sort out that issue. He, in all likelihood, saw it, and I believe the jury could have sorted it. There was enough evidence that the jury should have been able to look at that and sort out that issue. If there are no more questions, I'll move over to the flight instruction. Yes, Judge Inman. You're muted.
Thank you, Mr. Soar. Thank you, Z. Sorry. Can you just talk about the standard of review on this first issue and getting sort of meta about what the standard of review is and just where you think we draw the line in terms of what's sufficient? Knowing that there is certainly question about what Mr. Gibson could see.
Well, the standard of review, of course, is de novo, and there has to be sufficient evidence of each element. And of course, this element is whether he reasonably knew that an accident occurred. that he knew or reasonably knew that an accident occurred and that there was serious injury. The state does not have to X out every possible element of innocence that could possibly be thrown up. I don't think it's crucial that he would have seen the impact. I certainly don't think that is crucial. He may have seen the impact. I mean, I saw what Mr. Widenhouse saw, and yes, you could see that there was stuff in the trailer. Sometimes a mattress is put up in ways so you could see, you could still see back through the windows. As a matter of fact, Mr. Snook, I believe it was Mr. Snook, testified that he thought you could have seen out the windows and that he could have seen the accident. But I don't think it's crucial that he necessarily actually saw the impact, although I believe he saw the aftermath of it. But I don't think he would have had to seen the aftermath of it, because the people skidding along the highway and the motorcycle going up the embankment and breaking up into pieces, he probably did see it. I don't think it's crucial he did, because there was also the evidence of how he acted. And we never know exactly who saw what and what anybody knew. We know where their focus is. We know, was it possible to see it? Yeah, in this case it was, certainly. The people were skidding next to the trailer. The motorcycle was going up the embankment. And then how did they act afterwards? Did they act like they knew? These are the kind of judgments we make every day as to whether somebody heard or knew or understood something. And I think all three of these go together here. But I think there's plenty of evidence here that he knew an accident occurred or reasonably knew that an accident occurred and that there was serious injury. Have I answered your question? And you're,
Yes, you have. And if you could proceed on to the flight instruction issue. Thank you.
Okay, on the issue of flight instruction, of course, there was no objection, and it is plain error. And for plain error, the defendant must demonstrate that a fundamental error occurred at trial, where after reviewing the record, it can be said the claimed error is a fundamental error. So something so basic, so prejudicial, and of course I'm quoting Odom here, so lacking in its elements that justice cannot have been done, or where the error is grave error which amounts to a denial of a fundamental right of the accused. None of that happened here. But our argument is it wouldn't have been error even with the objection, because State v. Thompson differentiates between leaving the scene and flight. Leaving the scene, that could be for any reason. Maybe he wanted to get home and eat his pizza or watch a football game, or maybe just hurry up and make his delivery. But again, going back to Barnes, as you mentioned, Barnes says, we believe the speed and manner of defendant's departure from the collision site. So they kind of the speed and manner of the departure and his subsequent eluding of police. After he parked the car, he disappeared, I guess. And the speed and manner of the way Mr. Gibson left. First he slowed down like we all do when we get in an accident. Then he took off at a high rate of speed, tried so hard to stay away from Mr. Elfin, who he correctly guessed was trying to get his plate number and stay with him. How he was apparently called 911 after his tire was shot at, and then immediately hung up. Why would he do that? He's acting like he's at fault here, and then he deflected the question about what happened to your tire at the traffic, where he got his tire changed, and then asked for directions on how to get there without getting on the interstate. He was fleeing. He was fleeing apprehension. He acted exactly like what he was doing, that he knew he was in trouble and he needed to get away. And the flight instruction was very proper in this case. Are there, yes, sir. Yes, sir, Judge Collins.
Mr. Dalton. So, I mean, looking back at it, the prosecutor relied on the flight a lot in the argument, and why not? I mean, it's a very strong inference to make for the jury. But the totality of circumstances, when you're looking at, him getting pursued, the firearm being pulled out and shot at, there may be enough to get there with flight, but the totality of circumstances, do you not think all that together with the underlying charge itself wouldn't be confusing for the jury?
Your Honor, I have to admit, Judge Griffin, I was having a very difficult time understanding you, and it wasn't garbled or anything. It just, and Mr. Soar, maybe the volume was not high, very high.
Okay, I'll try it again. I was referencing the flight instruction. When the prosecutor made their arguments, it looks like they relied upon that heavily, which, most prosecutors would, because it's a very powerful instruction. But given the totality of circumstances where you have Mr. Gibson being pursued by a biker he doesn't know, you have somebody pulling a firearm out on him and taking a shot at him, I can see how it would go both ways. And given the totality of circumstances, do you not think that's confusing to instruct the jury on flight with that set of facts?
Well, Your Honor, what I would have to point out is the gun did not come out until after he swerved at him and tried to shake him off his tail. The gun did not make an appearance until later. And then why wouldn't he called 911? Why did he hang up on 911? Why wouldn't he want the police to come and arrest this man that was shooting at him? And he could have, why did he not want the people to know at the truck stop that somebody had shot out his tire? Why did he want to stay off the interstate? We think all of that justified the instruction. Are there any more questions? And if not, the state respectfully requests that the convictions be upheld.
Thank you. Thank you, Mr. Dalton. We'll now give Mr. Winehouse time for rebuttal.
Thank you. I'm pleased the court. Just a couple of comments in response to my friend's argument about both of these issues. He suggests that because the bike and body went off into the right lane and off the road, therefore Mr. Gibson could see that out of his side view mirror. There's no evidence of that at all in this case. In fact, the investigators, even though they found the van and found the trailer, made no effort to get in the van and even see what one could see, whether the van was loaded or unloaded. And I think we all know that the way side view mirrors work is there are huge blind spots. And just because something goes off another lane or past the emergency lane, that may well get out of the view of what is in a side view mirror. So there's just no evidence in this case that Mr. Gibson could see anything out of any mirror. And there's nothing from which this court should allow the jury to reasonably infer that he saw something in the emergency lane or off on the side, because again, even though he slowed down a little bit, he then speeds up, in part because Mr. Alphen is chasing him, and he's moving quickly, not likely looking in his mirror to see what might be off the side of the road, as he's worried more about the motorcycle that's on the other side of him that's chasing him. And again, once Mr. Alphen catches up with Mr. Gibson, he does pull out a gun and start shooting. And it sounds to me like the state wants the benefit of everything that happens before the gunshot and after the gunshot without factoring in that the gunshot would cause Mr. Gibson or any reasonable person to speed away from that motorcycle. I mean, I'm not going to stay around if somebody starts shooting at me. And so the fact that he kept going, I think, is not evidence of flight. Now, granted, he didn't tell the person at the gas station what happened, but I don't know that that's any indication that he was fleeing. He just didn't tell him what happened to the tire. And maybe he didn't want the person to know somebody was shooting at me. Oh, well, what were you doing that caused the person to shoot at you? So I don't think the fact that he didn't tell the person at the gas station that he'd been shot at is a determinative factor. And again, the state emphasizes he wanted a back way to get where he was going. Well, I've just got to tell everybody on this court, if somebody's shooting at me, I'm not getting back on the interstate where the guy with the gun is. I'm going to go a back way to where I want to go. So I don't know that that's an indication of consciousness of guilt, as more as at that point, somebody's shooting at me for whatever reason, and I don't want to get back on the interstate and come to risk of being up with the person with the gun again. So for those reasons, we would ask this court to reverse the judgments in this case.
Thank you, counsel, for your excellent arguments. The case is submitted.
Thank you, Your Honor.
Thank you.
Thank you, all judges.
Thank you.
You may gavel us out now.
Session of the North Carolina Court of Appeals is now adjourned.